I expressly do not consent to this court's jurisdiction and do not.
Well, then
Any
you are
rights.
not a named party. So if you're not consenting to this court's jurisdiction, sit down. It does call the case of BMC Rio LLC versus Nettie Whitlow and Yolanda Whitlow Tice.
Good morning, Your Honor.
Good morning, sir.
Morning, Your Honor.
Good morning. State your appearance, please.
All right. Ian Redmond, P70599, on behalf of the plaintiff.
And your name, ma'am?
Doshia Banks occupant.
Pardon?
Doshia Banks occupant.
Doshia Banks occupant, Your Honor.
Okay. So you're not Miss Whitlow?
No.
So what is your position in this case as you see it?
The moment this hearing begins, everything goes sideways. A woman stands up and bluntly announces she does not consent to the court's jurisdiction. And instantly, the judge fires back. Then you are not a named party. Sit down. From the very first seconds, there's tension. Someone trying to challenge authority and a judge who isn't having it. It sets the tone for what becomes a tangled mess of bankruptcy filings, property battles, and a suspected scheme of delay. Question for the viewers. If someone says they don't consent to a court's jurisdiction, should the judge still listen to them?
If I may, Your Honor.
Okay, good. Go ahead.
Ms. Banks claims to be an occupant of the property. She filed a bankruptcy case listing the property as hers. The bankruptcy stay was lifted, which gave rise to our motion to reopen the case. The order lifting stay I would like to present to the court because it has some interesting language in it, Your Honor, which includes, it is further ordered that the bankruptcy court finding this filing of this petition was part of a scheme to delay, hinder, and defraud VMC REO LLC. Additionally, Your Honor, the bankruptcy court ordered, let me see, notwithstanding rule.
As we move forward, the plaintiff's attorney explains why this case is back in court. A bankruptcy judge already ruled that one of the filings was part of a scheme to delay, hinder, and defraud the property owner. He brings documents showing multiple attempts to block eviction using different bankruptcy filings and even an out-of-state person claiming the home as their residence. The judge listens carefully as the attorney lays out a timeline that looks more like a strategy than a coincidence. Viewer question: do you think this sounds like a genuine misunderstanding or a coordinated effort to stall eviction?
4001A3, a bankruptcy rule.
Right.
Creditor VMC REO LLC may execute on its order immediately. The order shall be binding and effective despite any conversion of this bankruptcy case to a case under any other chapter of Title 11 of the United States Bankruptcy Code. Further, that the recording with the appropriate governmental entity of this order shall constitute a bar to refiling any case under any chapter of Title 11 of the United States Code as to the property located at 5779 Pinecrest Estates Drive, Ann Arbor, Michigan. Wow. The property in this case. A debtor in subsequent case under this title may move from relief from this order.
The attorney drops another bombshell. The original homeowner, Miss Whitlow, hasn't shown up to any hearing, not a single one. She's ignored deposition notices, failed to appear in both state and federal court, and skipped deadlines for required documents. Meanwhile, other people, including the woman claiming to be an occupant, are filing bankruptcies tied to this million-dollar property in Ann Arbor. The judge is realizing something big. Everyone involved in this property keeps filing legal papers, except the person who actually bought the house.
Based upon a change of circumstances or for good cause shown after notice and hearing. Said bar shall be for 2 years from the entry of this order or until such time creditor relinquishes their rights to the property. This order came out June 24th of this year. I have a copy for you.
All right. Thank you.
I will note, Your Honor, that Ms. Banks has filed an appeal of that order in the federal Eastern District of Michigan. That appeal is pending, but the status quo as of right now is that there is no stay, and that order lifting stay holds until such time as the appellate court does something. Additionally, Your Honor,
when the attorney describes all the missed appearances and fraudulent filings, the judge can't hide her frustration. Everything circles back to one point. The plaintiff legally owns the home, and every delay so far has been caused by shifting stories and absent parties. You can feel the judge's patience thinning as she tries to understand why the people actually responsible aren't present, yet others are jumping in with filings, objections, and claims to the property. Viewer question: should courts punish people who repeatedly file bankruptcies just to stop an eviction?
Yes, go ahead.
additionally, Your Honor, there is no stay from the appellate court. They have not issued a stay, and in fact, it would be appropriate that there would be a bond placed or an escrow order of some sort, because BMC has been the owner of this property for the past year and does not have access to it. Additionally, Your Honor,
There's more. Go ahead.
there's a lot going on.
Yeah.
Additionally, Your Honor, Ms. Whitlow, who, as far as I know, actually exists, but I don't have any evidence to that effect, has not appeared in any hearings in this court, did not appear for her deposition that she was noticed for in the federal case.
At this point, Ms. Banks, the woman who declared she didn't consent to the court, asks to speak. Nervous, she starts reading a prepared statement, claiming she's appearing specially and conditionally to protect her federally vested occupancy rights. But the moment she repeats that she doesn't consent to the court's jurisdiction, the judge shuts her down again. Then sit down. You are not a named party. The courtroom reacts, even with some light laughter, because the judge's response is blunt and final.
And in a federal case, the federal court issued a show cause order to Ms. Whitlow that she had to present certain documents from this court, which she failed to do. Her deadline to do so was, I believe, July 3rd. Let me confirm that. Oh no, July 10th. And she did not supply any of those documents. I can present that show cause order if you would like.
I don't know that I need that because
Okay.
I'm not.
The reason that I mention all of this, Your
Yeah,
Honor,
go ahead.
is that this is $1 million house in Ann Arbor that Ms. Whitlow purchased with a mortgage and less than a year later defaulted. The foreclosure went through, the sale occurred, the redemption period expired.
Suddenly, Miss Banks tries to recant her earlier statement. She tells the judge she does want to participate now. But the judge isn't fooled. She reminds her that you can't jump in and out of the court's authority depending on what's convenient. This moment exposes a major contradiction. Ms. Banks wants the court to listen, but she also wants to reject the court at the same time. Viewer question: do you think the judge was right to refuse her back-and-forth attempt to claim jurisdiction only when it benefits her?
We came forward to evict. Since then, there have been multiple bankruptcies. Ms. Whitlow filed two different bankruptcy cases. A young man who apparently lives in Arizona filed a bankruptcy case and listed this property as his residence. Ms. Banks has filed a bankruptcy case and listed the property as her residence. It should also be noted that Ms. Banks was a bankruptcy preparer and has been forbidden from the bankruptcy court from preparing bankruptcies for anyone other than herself. The order lifting the automatic stay talks about that scheme of fraud. I list all of these things to show that the scheme continues. And that's why we would like to reopen this case, because
The judge explains the truth. Ms. Banks never filed anything with the court. There is no paperwork, no legal standing, and no connection between her and the plaintiff. If she has a lease, the judge says, it's with Ms. Whitlow, the very person who refuses to show up. Meaning, the court can't help her, she's arguing with the wrong party, and her complaints must go to the homeowner, not the property owner. The judge is trying to keep the case on track, but the explanations raise more confusion than clarity.
there is no stay in place. We would like to move forward with an immediate eviction, at most an 11-day vacate. And if for some reason that would not be amenable to the court, we would ask for an escrow order or a bond. On $1 million property, I think it would be reasonable that $10,000 a month rent would be reasonable.
Right. Thank you. Ma'am,
Yes, Your Honor?
what do you want to tell the court?
Well, just for 60 seconds, and then I wrote something up because I am nervous, quite nervous. But I, Doshia Banks, is respectfully appear specially and conditionally for the sole purpose of protecting federally vested occupancy rights and opposing unlawful state action. I expressly do not consent to this court's jurisdiction. And
The judge points out that documents supposedly filed by the Whitlows aren't even signed, so she doesn't have to accept them. And since the actual defendants never show up, she can deny any request they made, automatically. This is where the judge finally draws a line. She's going to rule based on the plaintiff's evidence, because the other side simply refuses to participate. Viewer question: should courts deny motions if the filer refuses to show up in person?
do not.
Well, then
Any
you are
rights.
not a named party, so if you're not consenting to this court's jurisdiction, sit down.
Oh,
You can go because you're not a named party.
I have a lease.
You are not a named party on this. You may have a lease with someone else, and
No,
then
I have
you
a
can
lease
go
with-
challenge it. With who?
With Whitlow. Ms.
Then
Whitlow, who
you
is
need to
supposed-
go against Miss Whitlow.
Pardon me?
Then you may need to go against Miss Whitlow. But if you're not consenting to the jurisdiction of this court, you might as well just sit down. You are not a named party. I do not have to hear from you.
Oh, I see. So I need to,
I don't know what you need to do, but
well, let me respond.
to what? You're not consenting to the jurisdiction of this court. Why am I hearing from you?
I'm recanting
You're recanting what?
what I just stated.
Which part?
The part that
The judge grants the motion to reopen the case. She awards possession of the property to the plaintiff and authorizes a 10-day eviction order. Then she sets the appeal bond at $15,000 per month, higher than what the plaintiff requested, based on the home's value. Ms. Banks protests, saying her lease payment wasn't that high, but the judge immediately shuts her down, telling her she has no standing to argue the bond. Finally, the judge ends the hearing, admitting she needs a break because this case has been that exhausting. This hearing revolved around a $1 million foreclosed property where repeated bankruptcy filings were used to delay eviction. the actual homeowner never appeared, leaving others, including Miss Banks, trying to argue occupancy without legal standing. The court found that the bankruptcy stay had been lifted due to a fraudulent filing pattern, allowing the plaintiff to reclaim the home. The judge ruled in favor of the plaintiff, ordering eviction within 10 days and setting a $15,000 monthly appeal bond. The broader implication: courts will not tolerate the misuse of bankruptcy filings to block lawful property possession. If you enjoyed this breakdown of a wild courtroom moment, make sure to like the video, drop a comment, and subscribe for more real courtroom drama and analysis. Your support helps us dive deeper into cases just like this one.